The Corporate Transparency Act. What does it mean? Does that mean you're going to lose all of your privacy? You've put all this time and effort in putting together asset protection. Is it all worthless now because of this new federal law? In short, the answer is no. Look, I want to be real clear right out of the gate. In no way does this affect privacy or the charging order protection that you can obtain by setting up the right type of LLC with holding company strategy. If you do it right, you don't lose anything here. So I want to be real clear. From the privacy perspective, you don't lose anything because all you're having to do now, and I'm going to go over the regulations in depth here in a second, you are not going to lose the privacy from lawyers, from bad actors, from anyone in public record doing asset searches or looking to bring a lawsuit. The only people you are reporting to now is essentially the financial crimes, the enforcement network. It's called FinCEN. It's part of the federal government, where you are just reporting to them like you would if you were reporting your tax returns. Okay. And I joke about this all the time, but people don't have access to people's tax returns. That's why it took years to get a hold of Trump's tax returns. Everyone was trying. So I want to be real clear about this. You do not lose any of your asset protection. You are just as protected as you had been previously. But let's go into what this is. I want to give you a rundown of the law and give a better understanding of what to expect. So number one, beginning January 1st, 2024, the U.S. Corporate Transparency Act is going to require reporting corporations or companies, it's actually called companies, reporting companies to submit a report to the Financial Crimes Enforcement Network, known as FinCEN, about the personal information related to anyone who is in control. Now, they refer to it as the beneficial owners. So here's the good news. This mainly applies to people that are going to be putting together LLCs, entity structures, asset protection starting January 1, 2024. If you put together your asset protection already, you have a year to get ready for this enforcement, okay? It will not apply to you until January of 2025. So I just want to be real clear about that. Now, it's important to understand, though, as a quick summary, if you ignore this, once it goes into effect, if you ignore this, it can result in very serious financial penalties and some things that are really kind of stupid and ridiculous, but that's how the federal government is trying to roll this out. So why does this matter? Just like you have to be in compliance for your state law LLC requirements so that you'll maintain your asset protection, now not only do you have state regulations, you now have federal requirements. You need to be in compliance with both. Okay, so what is a reporting company? A reporting company, here it talks about only reporting companies are subject to the Corporate Transparency Act requirements. A reporting company includes any corporation, an LLC, a limited partnership, or similar entity created by filing a document with any U.S. state, territory, or Indian tribe, and any non-U.S. entity that registers to do business with any U.S. state, territory, or Indian tribe. Trusts, and it says here, trusts created by a filing do not need to report. This is critical, really important. Trusts are not included. Trusts are actually a contract. They're not filed anywhere. So since there are no actual filing requirements for a trust, if you have a trust, that is not going to be a part of the Corporate Transparency Act. Very important, okay? Now, these regulations were put out well over a year ago. Back in September of 2022, the Department of the Treasury issued their final regulations related to this. And essentially, here's what has to be provided. Each reporting company must provide the company's legal trade name, their trade name, or DBA, their doing business as name, their current address, the company's jurisdiction of formation. For a foreign reporting company, the state, territory, or jurisdiction where it registers, and the company's EIN number is required. Foreign reporting companies must provide a foreign tax identification number if they do not have an EIN. So you've got to give an EIN or a TIN number. Now, the beneficial ownership requirement, here's the key. In terms of what must you disclose? Well, reporting companies must identify each of their beneficial owners, as the law says. A beneficial owner is any individual who directly or indirectly exercise, and this is what's key, substantial control over the reporting company, or who owns or controls at least 25% of the ownership interest in a reporting company, okay? So the regulations provide guidance for what substantial control means and owns or controls. Here's an example. For example, if an individual has substantial control, an individual does have substantial control if such individual exercises a certain degree of power over a reporting company. like serving as a senior officer, president, CEO, CFO, or general counsel. This definition is broad and can include anyone who has the authority to appoint or remove directors, anything. Essentially, control sounds like what it is here. So you can have a partnership with multiple beneficial owners. But the main rule is if it's 25% or more, you must report. If you're less than 25%, particularly if you're limited in any control that you have, then you do not have to report. Also, some people say, well, how do I know if I'm required to actually report on this or not? Well, first of all, there are some limitations. There are exclusions to this rule. The exceptions, number one, are banks. No surprise there. Banks are excluded. Number two are large operating companies. If you have more than 20 full-time employees in the U.S. and or have an operating presence of at least 5 million in gross receipts or sales. So this is really targeting smaller businesses. It's not targeting larger businesses, okay? So this is important to know whether you own rental property, whether you have a property management company, whether you run your own separate business. If you're over 5 million in gross receipts, you may be able to be excluded from this. If you have more than 20 employees, you may also be able to be excluded from this as well. Publicly traded companies and tax-exempt entities are also excluded from this. Now, why does this matter? Well, look, it's not going to be, now I'm going to tell you how messed up the federal government is. They don't even have this available to register yet. So they don't even know for sure when they're going to roll this out. So well, they do, but they don't know how they're going to roll it out. So there is an actual website you're going to have to comply with. Originally, if you set up let's say you set up an LLC in January, you were originally going to have 30 days to be in compliance with this law. And if you did not register and provide this information within 30 days, you could end up being fined a $500 fine per day up to $10,000. And it also provides technically criminal penalties of up to 2 years in prison for willful disregard of compliance with this law. Now, they've now extended that to 90 days. So anybody who decides to set up their asset protection within the first at the very beginning of the year is now going to have a quarter. You're going to have 90 days to get in compliance as opposed to 30, which is good. There's also some rumors that may be extended further out than that because the federal government's got to get their act together. Okay. So why does this matter to you? It matters because if you want to not only maintain asset protection or make sure you actually are getting what you think you have, you've got to be in compliance with the Corporate Transparency Act. But secondly, you do not want to be penalized. The worst thing that could happen is to find out that you were supposed to be in compliance. Now you're not, and you're in a position where you're paying $500 a day and up to $10,000 fine. Okay, that's the total amount. So this is important. Be ready for this. You do not want to put this off, particularly if you're going to continue to buy properties leading into the new year. You want to make sure you're aware of that 90-day deadline. So I just wanted to give a quick rundown of this so that everybody knew what to expect. And of course, I'll have updates because this law will change. I can promise you there will be the enforcement mechanism of this will change over time. So hope this helps. I'll get you an update on any new changes.